Rule: thou shalt not sign. You do not sign a contract unless and until you've read it. Reading is important. Hi guys, welcome to Mamolao. Here we are again, standing on legal business. Today we are going to talk about the 10 clauses that you will find in a contract. Today we are going to talk about the 10 clauses that you will find in a contract ordinarily. Most contracts have these clauses for good reason, and I definitely want to explain them to you in a more understandable manner so that when you find a contract like this in front of you, you are not intimidated, right? First rule: thou shalt not sign. You do not sign a contract unless and until you've read it. Reading is important because you are binding yourself to something specific. So you need to know what you're binding yourself to. Okay, thou shalt not sign. Remember that. The first clause I want to talk about is the duration clause. So in the duration clause, we actually have information around the start and the end date. Start and end dates are important. You can have your contract apply retrospectively. Like, for example, you started doing the work, but the contract hasn't come yet. The contract will actually apply from when you started doing the work and not necessarily from when you actually signed the contract. So start and end dates, really, really important, right? Then you also have obligations of the parties. Obligations of the parties are what are you required to do in the contract. In other words, your job, the party A's job is to pay, and party B's job is to provide a service or to deliver the product. And then obviously there'll be details around that. What type of product is it? When must it delivered to whom? In what way, etc., etc., etc. So obligations are really, really important, right? Know what your obligations are in a contract so that you don't do something different. Then we have the breach clause. Yes. That clause, you know, when somebody says, I'm going to sue you for not doing your part of the contract, it's the breach clause, right? There are penalties there that state if you breach this clause and you don't do your part in the contract, then I'm going to sue you. This is what I'm going to sue you for, right? So it has penalties in there around what penalties are available to each party if the one party does not perform. Then we have the fees clause. Fees clause, everybody loves. However, it's really, really important for you to understand the fees clause. In fact, it's one of the most important clauses in the contract. Why? Because it talks all about the monies, right? You need to understand in the fees who's paying tax. Is the amount with or without tax, right? So that's something that's important that you need to know. If it's a border contract, you need to know, are you paying in rands or are you paying in a different currency? That also makes a difference, right? So you really need to understand the fees clause really well. Then we have the liability clause. The liability clause is a problem, guys. When you see the word liability clause, if you're in a hurry and you're looking at a contract, make sure that the first thing you look at, or one of the first things you look at, is the liability clause, because that states what you will be liable for should something go wrong. Ideally, you want to only be liable for what is the value of the contract, right? You don't want to be liable for more than what you are receiving in the contract or the value of what you are putting into the contract. And if you really want to protect your business, then what you want to do is look into business insurance. Sometimes they call it, if you're providing services, they call it professional liability. It's professional liability insurance. So you're going to need that type of insurance to be able to cover this liability clause so that in the event you are liable for something, then your insurance will pay for it and not you. And that will guide you into what you are agreeing to from a liability perspective, right? Because if you know I have insurance, then you know you can be liable for up to a certain point. But if you don't have insurance, the most advisable negotiation you can do is to actually just be liable for only the value of the contract. Nothing more, nothing less. Dispute resolution. So dispute resolution clause, sometimes they call it arbitration clause, but dispute resolution is more applicable simply because sometimes you don't get to arbitration. Arbitration is actually a process in dispute resolution. So dispute resolution is, for example, where you are resolving a problem or resolving a disagreement amongst yourselves as the parties doing business. You're resolving it outside of court. Because as we all know, court is an expensive exercise and it takes a very long time. So if you're in business, you want the least amount of pain to be able to resolve a problem. So dispute resolution is probably the best way to go in order to keep business moving, essentially. Then we go to the confidentiality clause. Confidentiality clause is exactly that. It's keeping the terms of your business dealings and the terms of your contract confidential between the two parties or the three parties if it's a tripartite agreement. You need to make sure that you are keeping intellectual property of each party confidential. You need to make sure that you're keeping information and data of each party confidential. You need to make sure that you're keeping the trade secrets of each party confidential. You know, this thing where people are taking pictures of contracts, right? You guys are taking pictures of contracts and you are posting it on social media. The confidentiality clause is actually very limiting in that regard. You need to be careful of what you are taking pictures of and posting on social media. And when people take selfies in the office, and there you are taking a selfie in the office, and you're not mindful of what's in your background, right? And you're not mindful to blur the files that are sitting in your background. Those are really important things to be aware of. So try to protect the integrity of the contract by respecting the confidentiality of each party, of all the parties in the contract. Then we have the force majeure. Force majeure is a fancy term, but what it essentially means is an act of God. And more simply put, it is an event that happens that you did not foresee as the parties of the contract. So, for example, the pandemic. We didn't know COVID was a thing until COVID hit us, right? So a force majeure event would be a COVID event where nobody anticipated that we would be in a pandemic and every other thing that happened during a pandemic that made a lot of people get to a point where they are breaching their contract because they actually cannot perform. They cannot deliver this thing because we're on lockdown. They are not able to provide the service because, people are sick or people are not well because of the pandemic, right? So that is a good example of a force majeure event, an event that nobody could have foreseen that happened. And because it's out of our control as both parties, then we forgive each other and we can do what needs to be done in order to either cancel the contract or to make or to have different terms in the contract to accommodate this particular event, right? Then we have termination. Termination is you need to know when to leave the contract. You need to know when to get out, how to get out if you need to get out of the contract, right? If somebody breaches the contract and you feel like your business is in danger, then you need to be able to enforce a termination so that you don't suffer any more damage then you've already suffered. So make sure you understand and know exactly how to get out of a contract, and make sure that the terms of the termination suit you. So don't be scared to negotiate what you want into the contract, right? As long as it's reasonable, you need to be able to have your say in a contract, regardless of how big the company is that you're contracting with. They will actually respect you more if you understand these clauses and you're able to negotiate what you want into those contracts, because that makes you a good partner to be with because you're applying yourself. Number 10 is what we call jurisdiction. I know it's a big term. You're agreeing as the parties to be bound by the laws of the Republic of South Africa, right? Because you're doing business here, everything is happening in South Africa. And even if you're contracting with a multinational company, you know that at least South African law must apply to this particular contract, right? And then if you ever have to go to court, then the jurisdiction will be South African courts. So it's basically just about which law applies to your particular contract, and South African law would be the best to adhere to. So that's jurisdiction. So that's your top 10. I hope you have learned a lot. I hope you can be able to apply these things. And when you do see these clauses, remember what Mamolao told you, and remember to not be shy to negotiate that contract yourself. You can do it. I believe in you. Go ahead. One of my followers asked about a contingency contract, especially in the field of franchising. So I want to explain a little bit more about what a contingency contract is. And it's basically rises and falls on a condition, right? The happening of a future condition. Okay. So what that basically means is as follows. You know, when you enter into a contract to buy a house, like an offer to purchase, and then when you sign this offer to purchase, it actually has a clause which we call a contingency clause, which means there is on the happening of a future event, then the contract will be binding on the two parties. What does that mean? One of the clauses will say this agreement is subject to or conditional upon the bank's approval of the loan. Now, if the bank doesn't approve the loan, there is no contract. Even if you've signed it, yes, even if you've signed the offer to purchase, if the bank doesn't approve your loan, then there is no contract, right? It's because of that contingency clause. Okay. So contingency means conditional upon the happening of a future event. I'll give you another example. In the franchising space, let's say the franchisee says, look, I'm going to enter into this franchise agreement with you. And then you say, look, there are certain conditions of this, right? For example, franchise agreement won't be binding on the franchisee if he doesn't get the lease agreement for the lessor, right? If the person leasing the property that he is eyeing to have this franchise on says no, and the lease doesn't go through, then the franchise agreement will not be binding on the franchisee. You see? So let me take it another step. So let's say you're selling face cream, for example. If you're a salesperson and you're selling face cream and the contract says you will get paid 100 Rand for every face cream that you sell, provided that you meet a minimum of 20 sales a week. That's very specific, right? And that provided is called the proviso, which is called the condition, and that's where the contingency comes in. Okay, so you're a salesperson. The assumption is you've already been trained on how to sell this particular product. If you haven't been trained, you won't be able to meet the conditions of this particular contract, right? You won't be able to sell the tab because you won't know how to sell it, what it is, what it feels like on your skin, etc., etc. So the assumption is you know how to sell. Once that assumption is met, then you go ahead and you sell. once you are selling that product and the contract is specific to say your reward is 100 Rand per tub for every 10 that you sell. Now, from a contingency contract perspective, you actually have to have a record or a system that can actually record your progress, right? So you go into the system and you type in that you've sold 10 of these, right? You could be selling 1 on Monday and then you sell another 9 on Friday. You've met your target. Then what happens is you get your reward. And your reward is 100 Rand times 10 for 5 days for that month, and then you get paid at the end of that month. Now, here is where it gets tricky. If you do not sell 10 in that week, there is no contract. We don't move to the recording and the rewarding. There is no contract. And I think that's where the TikTok viewer is coming from, because it becomes tricky when you actually don't fulfill the condition. If you don't sell, let's say you sell 8, you haven't met the condition, which means that the person or your employer actually then says there is no contract. We don't have the contract that week. You haven't met it. Unless there are other more simpler conditions around, if you don't make it 10 that week, we will give you grace for the following week, something like that. But strictly speaking, if the contract says you can only sell 10 per week and you fall short of that 10, there is no contract, right? Because that future event has not materialized because you didn't meet the first condition. So it's conditional. First condition, you selling. Sell 10 a week. Second condition, you put it on the system. It's recorded. There's no question about it. The third one, you get rewarded after that. 3 vital steps. If you can't meet the first step, the other 2 steps cannot activate, which means it's not binding, which means the other party is not bound to the contract because you did not perform according to the first part. Easy peasy. I hope that was clear. If you have any more questions, by all means, put them on the chat. Mamolao wants to hear all about them.